If to take your U.S. immigration related questions. Go ahead and put those questions in the comments. I have a good topic for you today. So, there is immigration relief for victims of abuse. There are different types of relief. Hi there, Marsha. It's nice to see you. There are different types of relief that's available just depending on the situation. Of course, there's always VAWA, right? With VAWA, if you are the son or daughter of a U.S. citizen or legal permanent resident and you're under 21, in some cases, you're under 25, and you were mistreated by that parent, there is this relief. So if you're here and you went through a situation like this, when you were a child, right up until you're now 24, you haven't reached 25, then we can look at potential options for you to apply for VAWA. Now, another option is if you are the parent of a citizen, that citizen is 21 or older, and that child is mistreating you. Now, when we talk about mistreatment, we don't necessarily mean that the US citizen adult son or daughter, they're physically harming you. Of course, that does count. But it also includes situations where that son or daughter, they're putting you through emotional turmoil. Hi there, Mr. Tusk on YouTube. They're putting you through emotional turmoil. They're doing things to affect you negatively, emotionally, mentally. Physical abuse does count. However, I need you to know, hi, Denroy, I need you to understand that it's not just physical harm because a lot of people have the misconception that they are not able to apply for this relief because the person did not hit them, or they didn't call the police, or they didn't report it to the police, or they don't have any pictures of any physical injuries. All sorts of abuse and mistreatment and extreme cruelty. So it doesn't just include abuse, but extreme cruelty does count to qualify you for VAWA. Extreme cruelty depends on what your situation is. It depends even on the extent of your own tolerance, your cultural expectations for yourself. If, for example, you have cultural traditions that your spouse or your parent or your son or daughter are refusing to adhere to, and it's affecting you emotionally, that could be a form of extreme cruelty. So, the extent of the mistreatment, the extreme cruelty, the abuse really comes down to particular circumstances, the context of the situation, and the effect on you. Right? So in this case, you do need to have a qualifying relationship with a U.S. citizen or legal permanent resident, parent, a spouse, or a U.S. citizen son or daughter who's 21 and up. But there are other alternatives here that I need to make you aware. And we do look at those alternatives for victims of abuse. So the one of those is through getting T status as the victim of trafficking. Similar to the VAWA, where a lot of people don't know they qualify because they think they need to be physically harmed or physically abused, so they don't think they qualify. For victims of trafficking, a lot of people have the misconception that victims of trafficking look a certain way, are in certain situations, that they were maybe tied down somewhere, that it only includes sex trafficking, and that's not the case. Just like abuse in regards to the VAWA situation, where you are emotionally mistreated, you're subjected to extreme cruelty, mental harm, you as well as physical, but physical is not required. The same can apply with trafficking. The traffickers involved can use different methods to manipulate the victim into doing what they want. They don't necessarily have to physically force someone, but they can do it through coercion. Coercion is a method that it could be a pattern of behavior, it could be a method that they use to psychologically manipulate the victim into believing that they have to do what they say they have to do, or a bad consequence is going to follow. So, for example, say in the case of the trafficking, right, where you may be the victim of labor trafficking or sex trafficking, depending on the facts involved. But say, for example, you were coaxed through fraud to come to the US. Say somebody here, it could be an employer, it could be a friend, it could be a family member, it could be anyone. Anyone can be a trafficker. And say this person said to you, come to the United States, I'll get you work, or I'll file for your papers, we'll get married. They make these promises and then say when you arrive in the United States, they either could smuggle you in. If they try to smuggle you in, because you do have cases where you're smuggled in and then it turns into a trafficking situation, or you come in on your a visa, or you're already here living, and you're coaxed then to do what the trafficker says. So they say, come stay with me or come work with me, and I will do all these things for you. I'll get you your papers, I'll get you a work permit, or I'll marry you, or I'll, in some way they're telling you that they can give you something that you want if you just do this thing. Then when you end up in that situation, it turns out to be completely different. This can happen over months, this can happen over years, this can happen immediately. But when you get there, then you find that you're not, now it's no longer a choice for you. You feel like you have to follow what the trafficker says, this person says. Because if you don't, now they change it from, I'll get you all these things. So if you don't continue to do these things, I'm going to pick up the phone and I'm going to call ICE. They're going to come and get you. Or as an employer, I have access, I have a number to call ICE and tell them you're not complying with me as the employer to do the work that you're supposed to. This can even happen, by the way, if you came in on a visa. So, say you came on an H-2B to work for a business, and when you came on that H-2B. That's the type of thing that you heard. If you don't do this, I'm going to call ICE. Oh, I can get you deported in a jiffy. Another atrocious thing, a pattern that I've seen, is that the recruiters of the employer will often they will often use, say, well, you have to have sexual relations, or you have to do something in order to get the job, or in order to keep your status, or in order to continue to get your H-2B visa renewed, right? Or in order to continue working in the United States. These are all red flags for trafficking, because what they're doing is they are getting you to do something you normally would never willingly do, by using fraud, coercion, and in some cases, even fraud. In some cases, employers and people that you thought were family members, you thought loved you, even maybe an intimate partner, turns to these tactics, which can also include physical harm or threats of physical harm, to get you to do what they want you to do. So, in this case, I have represented clients who have been lured here to come work. Oftentimes, the very common scenarios I see is as a caretaker for group homes, or assisted living facilities. They will come here. They will come on here under promises of getting certain benefits, and then it turns into a whole other nightmarish scenario. So, in other cases, I've represented clients who have had partners. So, the partner is not a US citizen, they may be illegal themselves, and they turn into the trafficker. You may want to leave the relationship, you may want to leave the situation, but you feel like you can't because they maybe have threatened you with harm. They have, maybe they have financial control over you, maybe they're taking your money. And these scenarios mean that you are being forced to do something against your will, for the benefit of the trafficker. So in this case, if you are experiencing abuse, this is my rule of thumb. If you're experiencing abuse or mistreatment or manipulation by an individual, it could be anybody, and you feel like you're stuck in this situation, you're being forced to stay in this situation, you don't have your papers, you may have crossed the border without permission, you may even still have current status, and you feel like you can't get out, or you felt like you can't. If this is not happening, this happened in the past, it still counts. You still can qualify for this relief. So if this happened in the past, no matter how long ago, I did represent a client who went through this 20 years ago, and they didn't realize until they spoke to me like a few years ago that they qualified for T status to get their work permit, to get their social security number, and to be able to get a path to permanent residence. They didn't realize until 20 years after it happened that they qualified, and we were able to get them the T status. So this is real relief that works, and it can serve as an alternative in cases where you felt like you were stuck and forced to be in that situation. So, what do you get, right, with the T status? With the T status, we basically do everything for our clients to make sure that they are safe through the process, and that we can get them through the process successfully and smoothly. At the point that we do represent our clients and we get everything filed and approved, they get a work permit. So they get a work permit for 4 years. However, keep in mind that during this time, there is the ability to apply for adjustment of status after the approval. Along with the work permit, you're able to get an I-94. And if you've had past issues, right? So if you've had what we do is we apply for waivers. If you've had unlawful entry into the United States, even if you've had past criminal conduct, there are waivers that are available to forgive it. And here's the additional benefit. When you do get forgiven and you're approved for the T status, it also means that you will be forgiven for those violations or those offenses to move forward to the green card process. So those waivers, that forgiveness carries through all the way until you get permanent residence. If you're approved for the T status, approved for the waiver, and then you move on to the green card phase, those will not be an issue as long as you were forgiven. So it is an option that not a lot of people realize that they qualify for. And I'm here to tell you these ways that, especially if you're here undocumented and you feel like there's no hope, there are alternatives based on the types of experiences that you've had with individuals in the United States, and based on your abuse, the abuse that you've experienced. This is where it's very important to get in touch, schedule an appointment, and we can talk about what happened with you and then get started. We'll figure out if you qualify for VAWA, if you were the victim of trafficking as defined under immigration law, or if there are other ways. There's also asylum, right? Because if you've experienced problems in your own country, and you're in fear of returning, and those problems are usually related to your persecution, meaning you're targeted in your country based on your race, your ethnicity, your religion, your political opinion, or any other particular group that you may be part of, for example, your sexual orientation or the gender that you identify with. If you've experienced, persecution on those types of, based on those types of issues, you may qualify for asylum to help you to stay in the United States and then be able to stay and get your asylum and then permanent residence. By the way, as a side note, there may be changes to the asylum law. They are now looking at if you've crossed the border without permission, you will not be able to apply for asylum. So this is something that President Biden is looking at implementing, and it's a policy that's meant to encourage people to go through the border instead of trying to cross illegally or unlawfully. So that's just something that may be coming down the pipeline in March that you should know about. Um, now, that should be effective after a certain date. So it shouldn't necessarily affect those who are already here. However, if after that time you've crossed the border without permission, then asylum may not be an option, and your deadline would have passed by time this new policy that they're implementing gets expired. So just one side note there with asylum. The last form of relief based on abuse that I want to talk about here is the U visa. So the U visa is for victims of certain crimes. In order to qualify as the victim of a crime, you would have to experience a crime that resulted in your physical or your mental trauma, right? So it had to have an effect on you to that level, that a significant effect on you. So, for example, if you've been the victim of domestic violence, assault, stalking, certain robbery, then this could qualify you to stay here while you're waiting for your U visa to be processed. You would be able to, at the same time, apply for your work permit and your travel document. The U visa is taking 7 to 10 years to process, so it is taking a while. However, they have implemented new policy to make sure that if the individual shows that they were the victims of the qualifying crime, that they also make sure they pass the background check, that they are able to then be placed in deferred action. That's a protected status where they won't take any actions against you. And with that deferred action, you're able to get the work permit as well as your social security, and to be able to stay here and live here while this process is going through. Once it's approved, then you do have a path to permanent residence. So you get 4 more years and then permanent residence. As a victim of trafficking and as the victim of a crime, not only you can qualify, but once you qualify, your family members can automatically get to apply as well. They have to apply with you, of course, but your spouse, your children under 21 and unmarried can qualify for the U status or the T status, depending on if you're the victim of a crime or you're the victim of trafficking. If you're under 21, there's an added benefit. Your parents can also qualify for this form of relief, and your sibling who's under 18 and unmarried can also qualify as well. So this not only extends to you as a victim of trafficking or the victim of a crime, but this extends to family members who needs this relief as well. So it is an important form of relief that offers alternatives for individuals who really feel like they have no other way to gain status. What you can do is, if any of this sounds familiar, if you've experienced abuse from an employer or a significant other, go ahead and give me a call and we can talk about it, determine whether you qualify, and get started right away. All right. So now that I have completed talking about the immigration relief that's available based on abuse, I want to go ahead and answer questions. The questions don't have to be related to the topic that I just talked about. It can be anything that's immigration related. And I see a few, so I'm just going to scroll through and find those. So I see some on YouTube as well. So I filed my case on September 12th. Filed your case on September 12th. How long it's gonna take to get my ED card, which is a work authorization. So it depends on what type of application you filed. If we're talking about adjustment of status, you're looking at about 6 to 8 months for family based. You're looking at 3 to 6 months for employment based, and you're looking at 6 to 12 months for VAWA. If it's for other types of relief like the T, then you're looking at after you become approved, which I'm seeing approvals come in 9 to 10 months. So you could, I mean, I've had situations where we've just gotten the work permit and that told us that our client got approved. So you just get the work permit after the approval. And then another important thing to note here with the T status as a victim of trafficking is that you're able to get assistance, so federal assistance like food assistance, housing assistance, medical assistance. You're able to get that with this status without necessarily being penalized for it. So all of these statuses that I talked about, VAWA, T, the U, asylum seekers and asylees, those who get it are approved, are able to get this. So when my clients have been approved for the T status, they get a follow up email. So I usually get it on behalf of my clients from the Department of Human Services. And what they do is they assign a case manager to assist the client to be able to get the support they need to thrive or to get past the trauma that they've been through. If they need medical assistance, they get that pretty much right after the approval. They can go ahead and get started on getting that form of relief. So, as an asylee, as a T or U visa holder, you're able to not only get the immigration relief, but you're also able, this kind of status enables you to get the kind of support you need to continue to thrive in the United States. All right. Hi there, Denroy. It's nice to see you. And it is a nice day. Thank you. All right. So I have a 2-year green card and filing for divorce due to cruelty. Is it a requirement for my divorce to be based on cruelty to remove my I-751? So, in your case, there are multiple ways. There are multiple ways to qualify to apply on your own. If your spouse is extremely cruel to you and you're going from the 2-year to the 10-year, that's definitely a basis to do it on your own. Divorces alone is also a basis. With both of them, you do have to show the bona fides of the marriage. Whether you choose both or you choose one is going to be based on the circumstances involved. In some cases, it may be straightforward to move forward with the divorce if you have a strong case to prove that yes, you divorced, but despite the divorce, you did enter the marriage in good faith. In that case, it may not be necessary to do extreme cruelty. However, filing multiple, which you can also help you to strengthen your application because if the officer decides that one is not going to work, the second one will, or the third one, which the third one is extreme cruelty. So it's, whether you choose one or all three ways to apply for relief is going to depend on your circumstances. And that's where it's very important to schedule the consultation and get representation through your process. It matters. These are cases that I go through with my eyes closed because I have the legal knowledge and the experience to go through it successfully with my clients and to advocate for them where it's necessary. So make sure that uh, make sure you protect yourself in the process. Um, Okay, so I filed my case on September 12th. How long is it going to take me to get my EAD card? I think I answered that one. I'm living here in the US and married with an American citizen for 4 years. Now we have one child and I have not applied to get green card yet. Is there a problem with that? I would say that. I would say that there is a problem if your US citizen spouse is not applying for your permanent residence. And if that's, it's usually when I see this, I know there are more things to come in the consultation, more details that reveal exactly what's wrong. But if you are asking here, if there's a problem with you not filing, taking so long to file, then it means that you need legal advice. Because if your spouse is the root of that problem there, that you're the reason you have not applied, then it means that you should at least schedule an appointment to look out for your own interests to see if you do have alternatives. And in the consultations, that's where I do talk with the individual to find out exactly what's going on and to be able to determine whether you need to move forward with a better option for yourself. All right. Can you only file naturalization if the green card is going to expire in a few months? So no, you can, as long as you qualify, you can apply for US citizenship at any point. Usually when you are a green card holder, if you're married to a US citizen and you're with your US citizen spouse, you could apply in 3 years after getting permanent residence. If you got it through family, or maybe you separated from the spouse before the 3 years, then it means that you have to wait the 5 years from the time that you got permanent residence. Now, keep in mind that you are able to apply 90 days before the 5 years and 90 days before the 3 year mark. But it's going to come down to, do you meet the eligibility criteria, not necessarily when your card expires. Can the I-485 be expedited? Yes, it can be expedited with a submitted request. However, when I am working with my clients, we make sure that the reason is going to be a good reason, because if you request it, it might be a waste. You can't just go to them and say, I want it expedited. There has to be a proper basis. So one is, if you want it to be expedited, is it that it's outside of case processing times? Maybe it's time to give them a nudge to get it going. If that's not the case, it's not outside of case processing times. The next question is, what's the reason? Is there urgent humanitarian need? Is there some medical need? Is there going to be some sort of big financial loss to others or to an employer? So, or did the USCIS make a mistake that caused a delay? And now, because of the mistake, you're asking them to push things forward. So it's going to depend on what the basis is, and they sometimes they do ask for evidence. Do you think it would be wise to pursue humanitarian reinstatement if parent petitioner passed away? So if you do qualify for humanitarian reinstatement, it does look like a good case. Absolutely, it is worth pursuing it. But that's where the consultation is going to be very important to figure out when was the petition approved. So usually you do have to have an approved a petition, and in some cases, while there are cases where you're outside of the United States, are you in the United States? What are your ties to the United States and so forth? And do you have a sponsor that can replace the petitioner to sign the affidavit of support? So go ahead, schedule an appointment, and we can talk about your situation and determine whether it's the best action for you. When you get your green card and travel for the first time, do immigration interrogate you at the airport? So, I mean, they can always ask you a lot of questions, especially if they maybe have doubts, because they do have to process you. So when you enter the United States with that immigrant visa and you're being processed to get the green card, when you're going through the airport, if they find something and they have additional questions, they can always ask those questions. It's never really been the experience of any of my clients, but that by the time they're entering the United States, everything is solid, and it's just a matter of them processing the paperwork and getting you through, within 45 minutes to an hour of arriving in the United States. So they don't usually just sit you down and interrogate you unless they get new information or something that's going to, make them want to ask additional questions. It's been a year since I filed I-130 for spouse outside of the US. Should I inquire now or give it more time? So if you're outside of the case processing times, then absolutely you can inquire. And you can do that through the USCIS. Can I file for only naturalization if the green card's going to expire in several months? So no, you can always renew the green card, and you can apply for naturalization at any point. What if you're waiting on naturalization interview and green card already expired? Is that a problem? So you want to have your green card with you for identification purposes. It does not mean that they're going to deny the naturalization, because an expired permanent residence card does not mean that you stop being a permanent resident. However, you don't want to be traveling outside of the United States with an expired green card. And if you say you're trying to get a job or you're trying to navigate business, you do want to have evidence of your status. And believe it or not, under the law, you are required to have your permanent residence card, and it is required to be current. But it's not something that's necessarily commonly enforced. So, an expired green card doesn't mean you stop being a permanent resident, and it won't stop you from becoming a citizen. But for other purposes, depends. So you never know how long the interview is going to be, how long from now is the interview going to be scheduled. If it's scheduled a long time from now, some do, even though with mine I'm seeing 2 to 6 months, maybe 8 on the long end of things. Other individuals, if they have additional questions or the application there's a delay for some reason, it could take over a year. And really, do you want to be stuck not having your permanent residence to show proof of your status for that period of time? So it's really a risk that you would bear not getting it renewed. Now, it is taking over a year to get that physical green card, but what they are doing is they're issuing extensions that allow you to still prove that you're a permanent resident. So you can still submit your application for permanent resident for a new card, and you'll get an extension letter to continue to show. That way you can travel and so forth. If I married a green card holder and he joins the army, how soon can he file the paperwork? So there's no rule that says you couldn't file the paperwork right after marriage. So there's nothing that says him joining the military is going to somehow, there's no timeline in regards to him joining the military. My follow-up question to you is it does it make sense to file soon after marriage or file after he joins the army? And that's where the consultation is going to be really important. So if you're working on an H-2B working visa and get married to a citizen, how long after you can apply for a green card? So, there is no rule rule that says you can't apply right away. However, is it a good idea, right? That's where individualized legal advice and representation is going to be very important, because there are other considerations to keep in mind. So before you do anything, make sure you get legal advice. But I have represented clients where right after they were married, they filed their permanent residence. However, in those cases, they were well prepared to file those papers because they lived together for a while, they were in a relationship for a long time, so all we really needed was the marriage certificate right after they got married. However, in other cases, if you are in a new marriage, maybe you just met and then you eloped, got married very quickly, then in a case like that, you have to be careful about the timing of your filing. And then in regards to the H-2B, how far are you in, and you want to understand how you filing is going to possibly affect your H-2B, and whether there are any implications of filing the petition while you're on the H-2B, right? So this is where individualized legal advice is going to be very important, and not only legal advice, but representation. So go ahead, give me a call, schedule your appointment first thing, and we can look at what's going on and get started on your process. Spouse I-130 processing slow. I applied a year ago, spouse outside of the US. So yes, unfortunately, it's frustratingly slow right now. The process is taking around 2 years, so 2 to 2.5 years if the spouse is outside of the US. The I-130 is taking anywhere from 9 months to 12 months to be processed. So it is all taking a while, but hopefully with the changes, they can speed the processing up. All right. Thanks so much for your time, everyone. I will be back tomorrow to be able to answer more questions. Thanks so much for your time. Go ahead, get in touch with me, schedule your appointment. It's really easy. Go to the link in the profile on Instagram, and go ahead, or you'll see the number here on the screen. You can also look in the description of the video on YouTube, and you'll see the link to schedule your own appointment. Go ahead and do that, and we can talk. So at this time, we don't have consultations on Saturdays, but we do have consultations on some days up to 5 o'clock. So you can go ahead, give the office a call, and they can tell you, because I really follow what my scheduling coordinators say. And so they would be able to tell you the days that are available, times that are available, best times to apply. So go ahead and call them. They will be able to tell you what my schedule looks like so you can get on it. All right. So thanks, everyone. Have a great day. Go ahead, schedule the appointment or call the number. The number is all over my videos. And then also make sure you like, subscribe, follow on Instagram, share this information with others. Let them know that I am, I do come here and I do educate people about the immigration process and different options, especially to those who do need to fix their status. So I appreciate your support, and I'll be back tomorrow. Have a good one. Bye-bye.